Okay, next is 202.56, Medical, Dental, and Podiatric Malpractice Action Special Rules. A. Notice of action. 1. Within 60 days after joinder of issue by all defendants named in the complaint in an action for medical, dental, or podiatric malpractice, or after the time for a defaulting party to appear, answer, or move with respect to a pleading has expired, the plaintiff shall obtain an index number and file a notice of MedMal together with the appropriate clerk of the county of venue. Together with, and then there's a list of 6 or 7 things, I think. Yes, so there's 6 things on the list that has to be included. Proof of service of the notice upon all other parties to the action. 2, proof that, if demanded, authorizations to obtain medical, dental, and hospital records have been served upon the defendants in the action. 3, copies of the summons, notice of appearance, and all pleadings, including the certificate of merit, if required. 4, a copy of the bill of particulars if one's been served. 5, a copy of any arbitration demand, election of arbitration, or concession of liability. And 6, if requested and if available, all information required by CPLR 3101. The notice shall be simultaneously served upon all parties. If the bill of particulars served pursuant to 3045 and the information are not available, they shall be filed when they become available and simultaneously served on other parties. And then it's got 2, the filing of the notice of MedMal in an action where a judge has not been assigned shall be accompanied by an RJI and shall cause the assignment of the action to judge. The notice shall be filed after the expiration of 60 days only by leave of court on motion and for good cause shown. The court shall impose such conditions as may be just, including assessment of costs. Then B talks about the preliminary conference. It says the judge assigns to the MedMal as soon as practicable after the filing of the notice of MedMal, shall order and conduct a preliminary conference and shall take whatever action is warranted to expedite the final disposition of the case, including but not limited to directing any party to do disclosure. Disclosure has to be completed within 12 months of the notice of MedMal. Timetable for depositions, to the extent feasible, be no later than 18 months for the notice issue and certificate of readiness, fixing a date for trial, signing any order required. Then it just goes on to that stuff. And C, and that's settlement conferences, which we all know is within 45 days after the filing of a note of issue and certificate of readiness, or if the party moves to vacate and that's denied, then 45 days after denial of the motion. Where parties are represented by counsel, it's the same as in residential foreclosures. Only counsel authorized to fully dispose of the action or accompanied by a person empowered to act on behalf of the represented party shall appear at the conference. When appropriate, the court may order parties, representative of parties, and insurance carriers or other person having an interest in settlement to attend the conference in person, telephone, or electronic media.